The best lawyers aren't found in the big law firms. They're found in the stories of those who left. Two, one. We are recording. All right. Welcome to the Self-Employed Lawyers League. I've got with me Joseph Palomara or Joseph Stephenson, depending how you ask him. Member of the league, and have known him quite a while because we worked together at previous places we won't talk about. But Joey, I'm going to open this one up with an unusual question. Because you're a criminal lawyer, you've been doing this a long time, you deal with that side of things. Does the presumption of innocence still exist in Australia?
Short answer is it is slowly disappearing. The longer answer, I think, comes back down to a whole bunch of different competing factors, and it all comes back down to time, right? So when we look at the presumption of innocence, there's a lot of work that goes into that in terms of the court system. So various different court steps, whether it's a mention, a contest mention, a hearing, special mentions, all for their own special purposes. But it comes back down to prosecutors, how much time they realistically have to go through matters. And when I say go through matters, not a quick skim of the brief and the charges, but to actually delve into the evidence and what they need to establish. Then also comes back down to the time of the solicitor as well. How much time is everyone spending on trying to get through what issues are in dispute? How much time is there for parties to, put aside, 90% of what is agreed on and deal with the 10% that's not agreed on? And the problem with that is because everyone is struggling so much of the time, courts are backlogged, prosecutors are running on skeleton staff, solicitors are juggling a million and one different things. Matters get into a bit of a holding pattern in court, and a holding pattern just means inefficiency. And then because of that as well, with the courts being so backlogged, there is this push at the moment that courts want to just clear matters, resolve matters, get them out of the docket, get them out of the system. And to do that is ordinarily to, plead guilty or resolve matters. So the presumption at the moment is, I would say, slowly eroding, and that is simply just because there's so much pressure coming in from all different angles on trying to just resolve matters, but not resolving matters in a way that might be, I don't want to use the word fair, but might be comprehensive in terms of resolving it, but more as a trying to clear the list. And that just comes back down to a whole bunch of different competing factors in terms of everyone's ability to really kind of spend time and go through matters in detail. So
do many matters even go to trial anymore? And actually get in front of a jury, where obviously that's where the whole system's supposed to be?
Yeah, there's at least from a Victoria point of view, if we look at, say, summary offences, which probably make up a large portion of what gets heard here in Victoria, there's three, I guess, key steps, right? There's what we call a mention, a contest mention, and a contested hearing. Ordinarily, most matters will resolve at some point in that first mention stage. Lots of discussions happen, things get dealt with. Very few matters then progress to a contest mention, and even fewer then progress to a contested hearing. What we're finding at the moment is probably a large portion of matters go straight to that contest mention stage. So, previously, a couple of years ago, throwing figures out there, but you might have 4 or 5 out of 10 matters go to a contest mention. Most matters now will go to a contest mention because matters don't have time to resolve. Prosecutors are not available, lawyers are not available, courts backlogged, and things just drag out. So most matters don't get to a contested hearing, but sometimes where we're at the moment is you just have to kind of push matters to that next stage just to get a resolution happening because everyone is so backlogged.
But a resolution, is it like predominantly them dropping the charges, or is it predominantly your clients pleading out to just get this?
It's a bit of both. And it's not uncommon for people just to plead out simply just to get the matter dealt with, because there's more delays to come in the next 6 months if they were to continue to fight it, or prosecutors haven't disclosed what they need to disclose, and there's issues on their end, or solicitors are not available for whatever reasons. And we get to a point where some clients, and it's happening probably more and more often, that people will just plead out because they don't want to spend the next 6, 12, 18 months in the court system. And it's becoming a problem because what we're then starting to deal with, fast forward a few years, is people then coming back saying, well, I've got a conviction on my record, or I'm applying for a working with children's check, or I'm applying for a security license, or, whatever it is, and then having issues saying, well, I've got this on my record now, but I didn't necessarily want to plead guilty. I did it out of convenience.
Yeah.
And that's probably the next shift that's starting to happen now.
Yeah, and that's, from what I can see, all the stats, it didn't look good. Effectively, if the state accuses you of it, you can sure try and fight it, but there's a more likely than not chance you'll lose, or you'll just get ground out. Because even if you fight it all the way and get found not guilty, you still have to pay that entire thing. So it's to me, it's a scary thing, because it's criminal law is the front facing of you, between you and the government, when they point their finger at you.
And to give you a perfect example, I'm dealing with a client now in custody on this exact same issue of a dispute that rests on a factual dispute. So it's his word against someone else's word. Not really much more in terms of evidence-wise. And he's been remanded and he's sitting in custody and he's been there for about 2 months.
Yeah.
All under the assumption saying that he's intending to fight these charges, but he's on remand. Now, we can get into a whole other issue as to bail and things like that, but there's reasons why, people are on remand. But in that 2 months, he's effectively lost his job. He's, on the brink of losing his home, all because there is this presumption of innocence that he's sitting in there. Now, whether he's guilty or not, is yet to be determined. But he's sitting.
No, but that's presumption of guilt, isn't it? Like, he's sitting in custody, presuming you lock someone away because they're a threat to society. Yep. We somehow, and I mean, goes back to the law school days, but when you actually study it, you go, it is honestly a miracle that someone at some point in history said there should be a presumption of innocence, because mob mentality says no. And that's where I'm like, for me, it seems like we're losing it. And if that's the case, clients getting locked away, that's the sheer opposite of a presumption of innocence.
And it's not uncommon now and again, that presumption it's not uncommon now for people to be sentenced purely based on the time that they're spent in custody on remand. Again, because they will just plead out to get out. And it's becoming a real problem at the moment.
Well, and then, it goes back to, it's not really rehabilitation, which is the goal, particularly for younger people, to try and get them in and out. So even with all the technology and everything, which is supposed to speed things up, which is supposed to improve particularly the administrative side, is it still not? Because ultimately justice takes time, and obviously there's a shortage of time, so therefore there's a shortage of justice. Has it not improved the last few years?
No, short answer is no. Technology within the court system is still, I would say, primitive. Most stuff is done via paper forms that you fill out and lodge. The court system itself is very, very basic, at least from a criminal point of view in the magistrate's court here. It only goes so far as being able to, lodge my appearance and maybe do an adjournment here and there, and that's it. There's no real other capacity on the court system. A lot of the negotiations purely fall down to the progression rate, purely fall down to picking up the phone and speaking to a prosecutor on the phone, or sending an email and dealing with prosecutors backwards and forwards on emails, which is difficult because prosecutors are running at a bit of a cell and stuff anyway, so it's making things difficult. But B, with a solicitor who's got a file load that they're in court or things like that, it's not uncommon that you get a call from a prosecutor whilst you're in the middle of court. Obviously, you can't answer it, and it might go another week before you hear from him again. So things just get delayed. So it's still the old sort of pick up the phone, speak to someone over the phone type of situation, which obviously is a bit inefficient at times.
Yeah. But are you guys, at least on the private side of things, so the defense side, are you guys using technology to at least help your side of things?
Yeah, and I think the biggest advantage to us from a technology point of view is just streamlining what I have to do on a day-to-day basis. The less time I have to spend on, doing administrative tasks on my end, at least frees me up to do more of the actual substantive work that I've got to do with the prosecutor. That stuff doesn't have time frames. It could be any moment that you get a phone call. For example, now I can show you right now that's a no caller ID coming in, and that'd be a prosecutor.
Yep.
So not answering that would be a prosecutor for a matter, which would mean who knows when
And
I'm
they go put it on the bottom of the pile, and I'll call him next week. Yeah.
Yep. So the more sort of stuff that I've got to do, kind of outside of the scope of court and things like that, just slows down the whole process. So yes, technology helps, but you're just going to be using it in the right way. It's about being efficient, managing your time.
Yeah. Yeah. Wow. And so, because you guys have been at this a while and you got a pretty big reputation down there in Victoria, how do you teach like the lawyers that you're working with, how like when to fight, when to really stand your ground and go, no, I'm going to bat for my client, and when not to? Because obviously when you're under that much time crunch, that's a big ethical, almost moral dilemma to go.
And there's probably a couple of competing factors here. I think one is you've got to have a bit of experience on your end and to know, pick your battles. And there's some arguments that are probably worth having that don't get had because of a bigger picture, and vice versa. So it's all about looking at the long-term game. What is it that I've got to achieve? And it might not necessarily be a particular small thing that I want to squabble over with the prosecutor to achieve something bigger. The other thing as well is the more experience you have with particular prosecutors, I think that's what we do quite well is we've got very close relationships with the prosecutors. So you know how they operate, they know how you operate.
Yeah.
And it becomes a little bit less formal in the discussions with them, and that is only because of that relationship there. And there's outcomes that we've achieved with prosecutors that, even I look back and think, very good outcome for my client, probably not something a prosecutor should have agreed on, or there might have been some reasons why they probably could have pushed back, but they didn't.
Yeah.
So it's you don't want to burn your bridges. I think the biggest thing that one of my pet peeves is seeing sort of junior lawyers going into court, and everything is an argument. Everything is a fight with the prosecutor. Everything is a problem. And all that does is burn bridges, right? At the end of the day, a prosecutor is, the enemy, if you want to call them that, but they're also a colleague. If you've got that professional relationship with them, I think you're going to achieve a lot more in that kind of sphere than if you go in there like a raging bull. And that's, I think, some of the biggest mistakes that I see with junior solicitors is that mentality of us versus them approach. Isn't going to do you any benefit later on, but it's also not going to help your own reputation, right? You don't want that reputation with a prosecutor that everything becomes a problem.
Yeah.
So I think the biggest thing that I sort of impart on the solicitors with us is have that good professional working relationship with the prosecutor, and it will bear fruit later.
Yeah. Well, and it makes sense because ultimately, when you look at it holistically, prosecutor, the system is designed that you hold them to, like you're holding them to account, because there would be clients, and this is the one thing I've never understood it, why people can't get through their head. How does a criminal lawyer defend some of their clients? I'm like, take one step back and look at, if we just assumed the government was right about everything, do you really want to live in that authoritarian nightmare? But a lot of people can't. But that's like your job as well, is to hold them to account so they can get the best result for the most just outcome for society.
And that's what I tell people is, and it's that exact question, how do you defend these people? And I think the way that I always sort of come back to that is we'll look at how you phrase that question. There's a perception there that's been kind of embedded in everyone and how you defend these people. No one asks a question as to how a prosecutor is meant to prove a case against someone, or that it's their responsibility to establish the elements of an offence and prove the evidence and prove the charge. I guess everyone's mentality is, well, how do you defend these people? And I guess the answer is, whether you're guilty or not, whether you did it or not, whatever the situation is, I think it's the responsibility of the prosecutor and the state to prove a case, not up to someone to defend themselves.
Yep.
Yes, when you get into the court context, yes, you're defending yourself, but the first part of that equation is a prosecutor needs to prove the case.
Yep.
I don't have to disprove it. The prosecutor has to prove it. So I think it's been embedded in people as to, everyone's guilty.
Well, I was going to say that, and you're right. And I'm thinking it through the words, because words to me have so much power with uttered, and that is correct. And that makes a big difference on the presumption of innocence. To even phrasing it like that, how do you defend them? Well, no, I'm not here to defend. I'm simply here to make sure there's no holes in that story.
Exactly.
They're saying all this is true, but if it's not,
the prosecutors bear that responsibility. The prosecutors bear that burden. It's their job to establish anything. And I think if we start thinking like that, that's when the presumption of innocence comes back into the equation. It's the job of the prosecutor to prove the offense against someone, and therefore the presumption of innocence is there. When you start to frame it as, well, I have to defend myself, that's where the presumption starts to disappear, because that whole shift has occurred. But that's been, I guess, embedded on people for so long. That's how everyone looks at it. And it needs to shift.
That becomes the norm. I remember listening to a podcast of a young lady who escaped North Korea. Her mother sold her out, and she was on this podcast explaining that the words, because they said, like, how does no one think about freedom? How does no one think about justice? And she was like, that's not a word in our vocabulary. Therefore, we have no ability to think about it. And I'm like, the same thing can happen over time. If people just shift the goalpost slightly, suddenly we go, no. Do you remember? It's the 1984 thing. Do you remember when there was a presumption of innocence? It's like, no, if the government points the finger, where there's smoke, there's fire. It's these things that people say. And you realize, I'm starting to realize more and more, having had family members go through the system, like, boy, oh boy, it's a dangerous thing when you're actually faced with the government coming down on you. Then you're like, oh, I wish this presumption was there.
And to give you another example, and obviously be a bit vague because it's currently before the courts at the moment, but there's a very big matter that we're involved with here in Victoria where the prosecutors or the police have filed charges against our clients without having prepared the material for the evidence, the investigation, the brief, anything. So they've filed charges. Some of these people are in custody, some are not, but they've been charged. We come back before the court only for prosecutors to turn around saying that they haven't got the case ready yet. They haven't compiled the evidence yet. 2 or 3 months go by, we're back before the court again, and they've got extra information or extra investigation or extra material that they've got. 3 or 4 months go by again, and the same thing happens again. And what it's enlivened the argument of is, well, why have these people been charged if that investigation hasn't even been concluded, hasn't even been prepared, none of that has occurred, or at least hasn't finalized. Yet these people have been charged and are now required to defend themselves against an investigation that really hasn't finished.
Yeah.
And that's that presumption coming back into it of, well, they should never have been charged in the first place because the state hasn't got the material ready yet. And it's currently before the court at the moment having this exact argument of, it's a bit of a chicken and egg approach of, police have laid charges, but the evidence isn't there yet because I haven't got it.
Yeah. That's in my mind, that's an admission of, we don't believe in the presumption of innocence.
And I think
just know in our gut, we know these people, we want them off the street. So we'll throw that at them and then wait. That's scary. Yeah.
Yeah. It's quite common. And I think to change that whole approach, not only does, the community's, understanding of how it all works needs to change, but it requires a bit more accountability from prosecutors as well. The court has to, at some point, intervene and stop this from occurring. But until that happens, it's just going to keep going down this cycle. There's not going to be any kind of circuit breaker that occurs. Yeah.
Well, and on that, because that's fundamentally my belief in law, is if lawyers had more time to either prosecute or defend cases, whether it's criminal or not, there would be more justice. And I don't think anyone can say more justice in society would be a bad thing.
Yep.
EAS Legal, the business model behind it, is that sort of a reason, or what is the reason you guys have chosen to operate this sort of consultant solicitor revenue share style model?
There's a couple there. I think one of them is to give the solicitors more time to actually do the nitty gritty work side of things. I think the biggest pressure that we see from solicitors on our end comes from time or lack of time, and that comes from a few different angles. It could be their file load, it could be their caseload that they have, that it's just, they've got so much going on at the one time that they're spreading themselves so thin. I guess one solution to that is to have maybe a team of lawyers around you to shed some of that load to, whether it is drafting or corresponding or whatever it is, but basically having a team around you to shed that load to free you up to do a few more bits and pieces that take a little bit more expertise. And then the other side to that time equation is all the stuff that doesn't require, say, a lawyer's expertise to do. Having to have arguments with, courts about filing, or having to chase clients for funds, or having to deal with cost agreements, or having to deal with trust accounting and all that sort of stuff that a solicitor would ordinarily need to be doing. But every minute they're spending on that, they're not spending on, negotiations with the prosecutor, or going through a brief of evidence, or trawling through CCTV footage or something like that. So I think what we want to try and do is anything that our solicitors don't really need to be doing, that they don't do. And what they need to be focusing on, they can devote their time to do just that.
Yeah.
And it's, I think it's something a little bit different. And most people aren't, I guess, used to working in that way. Most people are either, within a firm working as an employee, and yes, they've got access to some of those support services, but at the end of the day, they're tied to this employee-employer sort of relationship.
Yeah.
Or you go to the other spectrum and you've got someone who, John Smith, who's got their own firm, and it's a one-man show. So you're still doing all of that stuff yourself.
Yep.
If anything, you've just increased your own workload.
Yeah.
So there's those two. And I think where we kind of fit in is kind of that third step of people who aren't in that employee-employer relationship and tied to a desk 9 to 5, who want to have, their own practice or their own brand or their own name, but at the same point, then still want to have access to the support and the admin and the accounts and the paralegals and a team of people around them. So that's kind of the third step in that equation, I see it, and that's kind of where we sit in.
Yeah. And obviously that's how, for anyone listening, it's pretty obvious talking to Joey, that's where Cell fits in with helping to grow, because it is that halfway point of you can go out and try and do it all yourself. And 80% of law firms in Australia do. They're 80% are sole practitioner or otherwise. And I go, the wasted resources there of every single one of them is having to do the trust account, or they just go without and risk that. Every single one of them has to do the invoicing, the bookkeeping, all those administrative things that take them away from time on the phone with prosecutors or time actually resolving things. Very cool how he's doing it. So tell me, like, in terms of a day-to-day, if I was a lawyer, I'm a senior associate, I'm fed up. I can tell you thousands of them because I talk to them every single day around Australia. I've done the math. I see how much I've billed for my firm. And I go, even if I did a fraction of that, I could still have a good living and make it. But what's it like day to day? Like, what softwares do you guys provide? Is there research tools, admin? How does it actually look for someone?
Yeah. And I think that the other part to that as well is one common comment I get from speaking with colleagues in the industry as well, is they say, okay, well, yes, if I...
Picking up, it's a hell of a time because I'm asking you, what can someone expect when they join? A lawyer who's joining up, they're going to become a consultant solicitor. What's the lifestyle / the day-to-day like?
Reliable internet connection is probably the first thing I can say. I think the biggest thing for us is, I guess, giving our solicitors the tools that they need to be able to not worry about all those little bits and pieces that take away time from their end, right? So, for example, if there's issues with cost agreements or accounts, there's people behind the scenes that will deal with that for you. If it's issues with, booking in clients or having to, arrange documents from clients or stuff that I would say is more transactional, there's a team of people behind you to be able to do that. If there's things in relation to, your own day-to-day that they need help with, whether it's, issues regarding tech or issues regarding, their office at home or bits and pieces that, you wouldn't necessarily think are going to become, issues, but when you deal with them, throughout the day so often, it takes you away from what you need to do. So that, all that sort of stuff as well. We use Smokeball, which has quite a good sort of inbuilt AI sort of research tool in it that we have access to. And obviously, LexisNexis and all those other research tools that we've got access to as well. When it comes to research and things like that, I think one of the biggest pitfalls that I see a lot of solicitors do is they're the ones undertaking the research from scratch themselves. And I think, what's important in these situations is being able to delegate those tasks to, say, maybe a more junior solicitor that you've got working with you or a paralegal who can do the grunt work and go find the case law and go provide summaries for the solicitor to, spend a fraction of the time to kind of review and settle. That type of stuff, I think, saves a solicitor, hours and hours on end, which can be put into, the stuff that an experienced solicitor actually needs to be doing.
Well, and because the biggest, obviously, nerve-wracking thing for anyone, and this is a two-part question, so you say something nice about the Self-Employed Lawyers League, but it's the marketing and finding their own client side of things that people fear. How do you guys support that?
Yeah, so we do a lot of marketing internally as well. So we have an in-house marketing team that does quite a lot of marketing for us as a firm, but then also for the individual solicitors as well. So, there's probably two things that most of the solicitors that come to us either have and need it to be polished up or don't have it all. And that's a functioning website. And also a presence online. In this day and age, gone are the days of, Joe Bloggs walking down the street to their local lawyer, that's on their main strip of shops and using them. Most places don't operate like that anymore. Most places don't have a bricks and mortar sort of, front, right? It's all online now. So, we see a lot of people come to us with a very, very sort of standard, basic, WordPress website type of situation. And they come to us with arguably no presence online. And I think what we try and do is build both of those things up. So whether it's through our own internal marketing sort of team that they can, help build the website up, that type of thing. And obviously, in terms of business development and marketing, that's a huge, huge part to any lawyer these days, right? Is being able to build their own name, build their own brand. So, connections with other lawyers, connections with other professional services, whether it is, local community groups, whatever it is, we certainly push is probably the wrong word, but we help our lawyers get into those types of areas as well, right? The more that they can build their name, the better it's going to be for that solicitor. And there's, a million different ways they can do that. I think what scares most people is they haven't done it before and they don't know where to start.
Yep. Yeah, it is. And that is the one thing. It's to me, it's the only thing that would hold them back. Now that there's obviously programs like what you guys are offering, you go, okay, the trust accounting's off the cards, the admin's off the cards. When you need the support, it'll be there. That final piece is the BD, which is just putting yourself out there a little bit.
And most people aren't scared of doing the BD and scared of doing the networking and the marketing. I think what people are hesitant about is the time that you've got to invest in that side of things. And with the hours and hours of the admin and everything that goes along with, running your own sole practitioner firm, there's just not enough hours in a day and something's got to give. And normally it is the BD and the marketing because there's no immediate dollar value to that, right? If I'm not servicing clients with, cost agreements and admin and things like that, there's no funds coming in. So naturally I'm going to prioritize that. And the BD and the marketing kind of just goes on the wayside. I think, if we can save our solicitors a few hours a day on that admin side of things, if they are people who really want to go out there and build their name and build that base, that couple of hours could then be used on the BD and the marketing to build up that client base. So, you know, there's two types of I guess solicitors out there. There's those that save those hours every day because they want that work-life balance, and there's those who save those hours every day, still have a work-life balance, but utilize those, I call them leftover hours, for something that might, you know, yield a result in a few months, and that's your BD and your marketing.
Yeah, no, that's great. And now you and Adam been in the league. Well, you came into the Self-Employed Lawyers League as founding members. What's it like? What do you think? And do you think it's got a future?
Yeah, definitely. I probably put up, you know, referrals in there on a daily basis, and they get snapped up with people in there. So I think that the benefit in there is, you know, every solicitor has their own niche area, and naturally you're going to get clients that come to you on something completely left to center that you don't deal with. Having somewhere to refer that to, I think, benefits the individual solicitor, benefits them in kind of knowing, you know, where they draw the line in what they can do and what they can't do, but also creates that professional relationship with other firms. And there's naturally going to be some flowback work. So I think what I found really useful with that group is building those connections with other lawyers and other firms, because the way that I see it, it's kind of, it's marketing without having to invest in marketing, right? So, you know, naturally I do one particular area of law, someone in Victoria might do another area. If they get an inquiry of that nature, it might flow through to me. Now, that is a client that I never would have obtained, or never would have had the option of obtaining. So because of that professional relationship, it just frees up work between solicitors. I think that's really, really key in this industry. Otherwise, everyone's doing the same thing. Everyone's doing Google ads and, you know, marketing and this and that. But I think the professional relationship that you have with not only other solicitors, but other professionals as well. And I think that is really important. I think that's where Cell comes in and allows a platform for that to happen, where everyone is on the same page. Everyone there is there to, you know, business develop and market and build genuine connections. I think, you know, when I look at platforms like, say, LinkedIn, for example, it's good, but it's not there for, I guess, meaningful professional relationships. It's a bit of showboating. It's a bit of, you know, it's a bit of a forum to kind of advertise. But I think everyone's got their own agenda as to what they're trying to achieve on that platform. Whereas Sell, everyone's there for a particular reason. They want to build up their client base. They want to build up their name. They want to build up their reputation. I think when everyone's kind of got that common goal, everyone's helping each other out.
Yeah. Well, and I'd nearly flash across the screen when I edit this, the rising tide lifts all boats, because that's what we've seen. And as you know, I mean, we talk to you all the time. That's why we're hoping to build your consultant program, because 80% of law firms are either sole prac or one or two person firms. They're not getting the vast majority of the work. And that's, the only way we're going to get market share for everyone to benefit, and there's plenty of work out there, there's no shortage, is the public just comes back to the lawyer who they like. They don't necessarily care what you do. Like if you were the lawyer that got them out of DUI, they'll come back, hey, I've now got my life in order. I'm going to buy a property. Can you do it? No, I don't, but so-and-so does it. And so that's where I go. If we can have that referral network, sky's the limit of how big it can grow. And then, like you said, everyone's going to have their niche. There'll be firms grow, there'll be boutiques grow to hopefully become massive programs. But if everyone inside that's building their client base, using their own network, it's kind of remarkable how big and how quick it can grow.
Yeah. And I think the other thing as well is you look at the reason why solicitors leave a traditional firm to go do their own sort of thing. And I think that's why you know, there is such a high number of sole practitioners out there. People leave that traditional model because they're not getting compensated, you know, correctly. You know, yes, there might be a high wage, but when you divvy that up by how many hours you're actually putting in, it's shocking. It's the time constraint, you know, working 10, 11, 12-hour days, and not essentially getting compensated for that, you know, all the back end sort of headaches that come along with it. So if they're the main reasons why people leave a traditional firm to go start their own firm, those problems don't disappear. And I think, in my view, they only become more problematic. You're spending more time doing admin. You're spending more time working. So I think people have this idea of being a sole practitioner is kind of the way out, and it is, but you're going to hit a ceiling at some point where you're going to need that extra set of hands in that support network. And I think that's where we're trying to look at the moment is, well, how can we solve that issue?
Yep. Centralize some of the services to distribute out. And that's, so everyone can just focus on be a hell of a lawyer in terms of BD. I literally coach people to do BD and I tell them, just be a hell of a good lawyer, and clients will keep coming back and they'll tell their friends.
Yep. If you're good at what you do, you will always have clients coming in. It might not necessarily be, an avalanche of clients in the beginning, but it is a snowball and it will occur, and you'll get a reputation of being good at what you do, and that is ultimately what drives clients.
Yeah. No, fantastic. Well, what's the best way if people are interested in learning more, getting a hold of you, if there's someone who needs a lawyer? What's the best way?
They can jump into, so my details are all within, for anyone within the league. My details are obviously in there, and they can feel free to reach out to me through that. Otherwise, you can jump onto our website, easlegal.com.au. My contact details are up there. And I encourage anyone, you can contact me personally. I'm not the type of person that, sits behind, a wall of assistants and you've got to get through them first before you get to me. My mobile number is available on our website and you can pick up the phone and give me a call directly.
Yeah. Fantastic. All right. Thanks, Joey. And I'm sure it won't be the last podcast we do.
Anytime. You're welcome.